Hi, this is Vivian from Pharmasalon. Before you watch, I want to let you know that if you're interested in getting a CE credit for this video, go to the show notes below. There's a link to the Compounding CE website that will take you directly to the quiz for this class. The show notes also include the questions on the quiz, so be sure to check them out. While you're there, don't forget to like this video and subscribe to this channel.
Okay, welcome everyone. I'm Rachel Fonticus, and I'm here with my colleague, Emily Hussey. And I am a partner, Emily's counsel at Reed Smith in the Life Sciences Division. We represent all types of compounding pharmacies, outsourcing facilities, traditional compounders, hospital system, pharmacies, physicians' offices that compound. And we're going to talk today a little bit about FDA inspections and responses, and we're going to focus on what happens during the inspection. So we're going to give some background. Vivian's got a couple great questions for us, and we will just go through this inspection process. Okay. So we'll just put our slides up.
All right.
Okay. So as I said, we're going to do FDA inspections and responses. We're going to really focus on what happens during the inspection. Okay, just wanted to say before we begin, everyone, that we have no conflicts of interest.
In addition, these are the learning objectives that we're going to go through for this presentation. The first is going to be understanding FDA's process and procedures for inspecting compounding facilities. We'll then turn to kind of giving an overview of understanding what FDA inspectors are permitted to inspect and by law what they are not permitted to inspect. It's important to know the distinction there. And then finally, we'll move into understanding how staff at the facility should interact with FDA during the course of an inspection and the problems that pharmacy staff can experience when dealing with FDA inspectors in what can be a really high stress situation.
So we're going to put out some foundational issues first, just so that everyone can get their bearings around an inspection, what's happening, what the different things FDA is looking for. And we start with the foundational question of why can FDA inspect my facility? Sometimes we do get this question a lot, or sometimes from clients, and it's because FDA does have jurisdiction over places where drugs are manufactured, processed, packed, or held. So if you think about any place where a drug is held, that is going to be a pharmacy, whether or not those drugs go across state lines, we'll get to that in a second, will be a physician's office, will be an outsourcing facility, will be a hospital pharmacy. So FDA does have that jurisdictional authority and they can come in. Now, this issue of drugs must be intended for introduction into interstate commerce, that also includes if the drug has any components that were in interstate commerce. So even pharmacies or outsourcing, that wouldn't be an outsourcing facility necessarily, but pharmacies or physicians' offices or that are only servicing in-state are going to be subject to FDA jurisdiction. And FDA very much views its mission as public safety and public health. And therefore, any place where drugs are being held, FDA is going to have jurisdiction. So that's why can FDA inspect my facility? There's also an outsourcing facility. Outsourcing facilities register with FDA, so that's more obvious. But this general inspectional authority, of course, applies to them as well, but it's broader than that.
So Rachel discussed why can FDA inspect facilities. Now I want to talk about why will FDA inspect compounding facilities. So as many of you probably know, FDA began focusing more on compounding facilities in around 2012 after the New England Compounding Center incident, in which there was a meningitis outbreak caused by compounded medications from that facility. It resulted in over 700 injuries and about a little over 100 deaths. So that led to legislative hearings. It led to a lot of renewed interest in FDA's responsibility to, more closely oversee compounding facilities. So that has kind of launched this, drive to start inspecting facilities more. In terms of why FDA will come into the facility, it's usually three things. The first is routine inspections, where it's simply just, your facility's name has come up in the pile of the list of facilities that are under their designation to inspect. Sometimes it can be a for-cause inspection, and that usually occurs when, for example, FDA has received a MedWatch report or some sort of patient complaint that gives them reason to be concerned and want to initiate an inspection of a facility. And finally, there are what we call risk-based inspections, and that can often depend on the nature of the compounding that's occurring at the facility. So for example, if you're engaging in sterile compounding or hazardous compounding, more complicated processes that the FDA is aware of, that then they will decide, this facility over this facility in terms of which they want to go to inspect. So that's why they will come into an inspect a facility related to compounding.
So when FDA comes, so now we've established they have the authority. What can they do? What will they do, or are they doing? When they come into the facility, the first thing they're going to do is if they will make a determination of if the facility is complying with the FDCA criteria. And as of course, the first matter, the question is which FDCA criteria, right? So they start by saying, all right, we're going to make a determination of what type of facility this is. Is this a manufacturer, a distributor, a compounder, outsourcing facility? Of course, compounder could be a hospital pharmacy, it could be physician's office. And they're trying to determine which pieces of the FDCA are relevant for them to inspect against and which of these are irrelevant. So, for example, for the traditional pharmacy, they will initially consider to see if that pharmacy is meeting the 503A criteria. They will look at if a compound is dispensed pursuant to a patient-specific prescription, and they will also look at if the compound is prepared from a bulk substance according to the 503A criteria. We're going to talk a little bit more about what they're using. They're using guidance documents to evaluate the pharmacy under those criteria. So they'll look to see that. And if FDA determines the facility is initially compliant with these criteria, it is not going to apply good general manufacturing practices, the CGMP, the common good manufacturing practices, CGMP. Not going to apply those. It will apply, consider that pharmacy to be a traditional pharmacy other than an outsourcing facility, right? And it will apply the 503A criteria. But what FDA is going to apply, regardless of whether it's an outsourcing facility or traditional pharmacy, whether CGMP applies or it doesn't apply, FDA will be applying the sanitary conditions final guidance, which now Emily is going to talk about. So just to kind of an overview, FDA comes in, makes a determination of who are you, traditional pharmacy, outsourcing facility, something else, manufacturer, distributor, whatever. Then they use the criteria we've articulated, and then they say, okay, now we're going to evaluate you under 503A, which of course doesn't include CGMP, or 503B, which does include CGMP. We'll be talking about that a little bit later. But regardless, FDA is going to apply the in sanitary conditions final guidance, which now Emily will talk about.
Right. So, FDA's and sanitary conditions guidance is kind of a unique beast. It applies to both Section 503A and 503B facilities. And just to kind of set the stage, as you may know or may not know, and you're learning for the first time here, under Sections 503A and 503B of the Food, Drug, Cosmetic Act, compounded human drugs are exempt from certain provisions of the Food, Drug, Cosmetic Act if certain conditions are met. FDA takes the position, however, and many of us in this industry would quibble with this, but it is FDA's position at this time, that compounders are not exempt from the general rule that drugs are deemed adulterated if they were prepared, packed, or held under insanitary conditions. So that's where we get this guidance, because if you decide to go into the Food, Drug, Cosmetic Act and you want to noodle around with it, it's a bear of a document, but what it won't tell you is what exactly insanitary conditions means. So FDA has put together this final guidance document that is designed to do just that. It was issued in November 2020. It applies to human and veterinary compounding. And the focus is typically on conditions in which sterile compounds are made, but it does address both non-sterile and sterile facilities. So it's important, regardless of the type of facility that you're involved with, that you want to read this document and understand it, because it applies pretty much across the board. From FDA's perspective, insanitary conditions are conditions that could cause a drug to become contaminated with filth or be rendered injurious to health. It doesn't actually have to be contaminated in order for FDA to find that there are some sanitary conditions involved. So it's important to know that. They don't have to find that in order for there to be some violation of this guidance. So what are some examples of insanitary conditions? It could be vermin. I think that's a pretty obvious one. If FDA comes in and finds insects or rodents or some sort of animals, I think that's a pretty clear indication that this is probably insanitary conditions, and FDA is going to have a problem with it. But there's, those are obvious. There's also a lot of less obvious ones. For example, maybe some water leakage in an area that's adjacent to the compounding space, or, simply handling of bulk drug substances or other hazardous drug products with inadequate controls to prevent cross-contamination. So, it can get a little more fine-tuned in terms of what they consider insanitary conditions. I also want to note that the guidance document is not exclusive. So there are other things that the FDA could find in sanitary that are not necessarily listed in that guidance document. So it's important to know what it says, but be aware that it's going to be a bit fluid and more of a case-by-case basis. One of the things that the industry noticed when the insanitary conditions guidance came out is that it really looked a lot like components of CGMP, basically dressed up as insanitary conditions. There's a lot of overlap there. And there's a lot of standards that are outside of USP 797. So, the industry struggles a bit to catch up to what are these kind of wholly separate standards from what normally apply to a compounding, Section 503A, which is USP 795 and 797. And then you have these CGMP requirements for an outsourcing facility. There's a whole separate bucket now of insanitary conditions to consider. So that's just kind of a flavor for what FDA is going to be thinking when they come in the door with regard to insanitary conditions.
So thank you, Emily. Another thing FDA is going to look at is it's going to apply the bulk substance guidance to Section 503A and 503B facilities. So to traditional compounders and outsourcing facilities. So here's another guidance. The guidance comes from a rule. There are two separate rules. Actually, it's a piece of the statute. These are not regulations. So two statutory provisions which govern the use of bulk substances in compounding. One is under Section 503A, which allows compounding if there is a USP or an NF monograph for the bulk substance, if the bulk is actually a component of a commercially available drug, or if it is on the bulk's 503A list. So I just want to back up for a second and define what is a bulk substance. Many of you may know this, some of you may be hearing this for the first time. A bulk substance is active pharmaceutical ingredient, or it is sometimes called API. And the active pharmaceutical ingredient is the active ingredient in making the drug. So when this sets up parameters for how those things can be compounded. So that's for Section 503A. In 503B, or an outsourcing facility, the outsourcing facilities actually has a more stringent limitation for how or which bulk substances can be used. An outsourcing facility can compound if drugs are in shortage. That actually has nothing to do with bulk, but I just wanted to make sure and put that in there because that's going to be an exception. Or if the drug is not in shortage, it can compound from a bulk substance that appears on a list that's developed by FDA for which there is a clinical need. So two different statutory provisions. One, more liberal in the 503A. There's a USP, NF, it can be used, or component of commercially available. And if not any of those things, then this substance has to be on a list. 503B, much more restrictive. These substances have to be on a list for which there is a clinical need. So these are the statutory provisions, right? But now there's a guidance. And what the guidances do is there's two separate guidances, a 503A guidance and a 503B guidance. And they set out an interim final guidance, that's what those guidances are called, and they establish 3 types of categories. There's category 1, 2, and 3. And category 1 are those that FDA is going to consider permissible. 2 are not permissible. And 3, basically FDA doesn't know. They don't have enough information as these substances go through the process. And that's going to apply to the bulks in 503A that don't have the USP/NF or not a component of commercially available. And it applies to all bulks used by a 503B. So during inspections, what is FDA looking for? They are using those categories. They're looking to see what category are the bulk substances that a compounder is using. Are they on that list 1? And if they're not on list 1, even if they're on list 3, FDA has been inspecting against it. And they have been noting, they have been issuing Form 43s on this basis. It is definitely something that they are inspecting against. So that's where that guidance comes in, is in the categorization of what is this bulk, 1, 2, or 3, 1 being permissible. Now, another piece of the guidance that we put down as our last bullet here, which is pretty important, is that FDA is really looking at the sources of the API. Where is this stuff coming from, right? They want to know. And what they want to know and see documentation of, and we've seen this in several inspections, is that these materials are being sourced from FDA registered manufacturers, not just distributors. So a lot of times the outsourcing facility or traditional pharmacy will be using a distributor, and that's how the drug supply chain works. And a lot of times the distributor may give an assurance or say, no, this is from an FDA registered manufacturer. FDA wants the pharmacy to have documentation of that fact so they can definitively demonstrate that their sources are coming from FDA registered manufacturers. And they have been auditing that and auditing the documents of that. Okay, and that's something that is required of both 503B and 503A and is being enforced. So the key takeaway from this one and these guidances are FDA will look to see that the substances that the compounder are using are on category 1, that they're going to look at that. And they're going to look, where are you getting those substances from? And they want to see documented paper trail that they're from an FDA registered manufacturer.
All right. In addition to the first 2 guidances we discussed, FDA is also going to apply, it's essentially a copy final guidance to both 503A and 503Bs. And just to be clear, there are actually 2 separate guidance documents, one for 503A and one for 503B. I think it's obvious to most people that compounders are not allowed to make copies of approved drugs. We're not a manufacturer of approved drugs. We're making compounds, which is a wholly separate thing. But, what is considered essentially a copy? Now, Section 503A prohibits compounding copies or essentially copies of commercially available drugs in inordinate amounts. So when FDA comes in and they're looking through your compounding processes and they're looking through the records, what they're going to be looking for is a couple things. First, they're going to be thinking about what are the commercially available products that look similar to the ones that you're compounding. Those commercially available products need to be actively marketed. So that's not something that's on the FDA drug shortage list, and it's not something that's no longer actively marketed. We're talking about active, commercially available drugs currently. You're then going to look at whether the compounded product has the same API as the commercially available drug. Even if it has the same API, they're going to then look as if the API is in the same, similar, or easily substitutable dosage strength, which typically is within 10%. And then finally, they're going to look at whether the compound can be used by the same route of administration as the commercially available product. For example, is it topical? Is it taken orally? Things like that. All three of those factors need to be shown in order for FDA to deem something essentially a copy. And even if they do find that, there's consideration that has to be made to whether or not these compounded products are being made in inordinate amounts. And then even if all of that is true, they have to consider whether the prescriber has determined that the compounded product has a change for the identified patient that produces a significant difference from the commercially available product. So it's not easy basically for FDA to find its way to deem something essentially a copy, but it's very important to know the different factors that go in for a Section 503 facility to determine what is considered a copy. I think when you think of a copy, it seems obvious, but that definition is actually a much more nuanced discussion of what is considered essentially a copy of a commercially available product. Similarly, but slightly different, I think it's important to know that 503A and 503B do have slightly different definitions. Section 503B prohibits outsourcing facilities from compounding essentially a copy of an approved drug. And in that case, FDA is looking for the following. One, whether the drug is identical or nearly identical to an approved drug. And there's a couple factors in there to think about. So it's looking for whether it has the same API. It's looking for whether it has the same route of administration, whether it's the same dosage form, the same dosage strength, and whether it has the same excipients. So it's the same, but a little slightly different analysis than Section 503A. So it's important to know the distinctions there. In addition, FDA is going to look at the commercially available drug and the compounded product and decide whether if there's a component or a bulk drug substance in this case that is also a component in the approved drug, they're going to look to see whether that drug provides a clinical difference for the patient. So again, it's slightly different than whether there's a significant difference in the context of 503A. In this case, 503B is looking to whether or not the compounded product provides a clinical difference for the patient. So one thing I would recommend is when you're looking at these guidance documents, there's really good charts at the very end of both of these that go through kind of a flow chart of how to think about whether something is a copy or essentially a copy. And typically when we're talking to a lot of our clients, we advise them, take a look at your formulations, take a look at the material, the compounded products that you're typically making, and take a look at this flow chart and see if you can make it all the way through to no, and because you'll want to be prepared for that if FDA comes in and conducts an inspection. So that's the essentially a copy guidance.
And here's one more guidance that we're going to go over that's used during inspection. And this is for outsourcing facilities. We talked in the beginning about how 503 traditional pharmacies do not have to comply with CGMP. Outsourcing facilities do have CGMP requirements, but there's no regulations to interpret CGMP for outsourcing facilities. What we have are a series of guidances, and they have been revised. The agency's been working on them. Our latest revision is January of 2020. We're on revision 2, and they set out what's called in the industry this CGMP light category, and therefore outsourcing facilities. So first thing I want to note, and it's my final bullet on this slide, but I'm going to note it first because it's kind of important. There have been no proposed regulations. Agencies have been working on regulations, and these processes, the CGMP processes required for outsourcing facilities, are pretty critical to how outsourcing facilities operate and to the drugs they can produce. And what we have is this 2020 revised guidance. So these are the expectations of the agency, and this is what FDA will be inspecting against if FDA comes into an outsourcing facility, when they come into the outsourcing facility. I want to note, because a lot of times we get a question, oh, well, I'm USP plus, and I'm really close to CGMP. And I think that's probably close to what an outsourcing facility will be evaluated against in these guidelines. These are pretty different from USP. So if anyone is thinking that or has a traditional pharmacy and they think they want to see, well, okay, what is really required of an outsourcing facility? Our recommendation is always that you pull this guidance and take a look at it. And like Emily said, for essentially a copy, there's a very useful chart at the end of this guidance, which groups things to help one understand what the agency expectations are. So it's a pretty detailed guidance. I only put a few bullets here to go over, but I think these are the important distinctions between what a full-blown drug manufacturer would be required to do under CGMP and what an outsourcing facility is required to do under the CGMP Light. So it focuses really on smaller batches to allow the outsourcing facility to produce smaller batches that are, of course, larger than maybe an individual prescription by prescription. That would be more traditional pharmacy or 503A activity, but not such a large batch that it would be economically unfeasible under full-blown CGMP of a drug manufacturer. I know that was very much the agency's goal in this revision. So what did it do? Well, for small batch sizes, it limits stability testing that could be conducted to support BUDs provided certain conditions are met. And again, limiting the testing is of course going to make this more economically feasible, that batch size more economically feasible. Same for default BUDs are not going to be applicable to large batch sizes. So they can establish BUD based on limited stability testing. And that testing, of course, is detailed in the guidance. And then another testing kind of relax of a full CGMP requirement is that in lieu of testing each shipment of components that are not approved finished drug products, a supplier's C of A can be evaluated to determine whether the lot can be used, provided it meets certain conditions in the draft guidance. So these three things are very much emblematic, in my view, of how this guidance creates that CGMP Light, again, to allow more relaxed standards, to encourage and allow smaller batch sizes to make it economically feasible for the outsourcing facility while still meeting the CGMP criteria. So again, I'm going to start where I end where I started, with there are no proposed or final regulations. So this is the guidance document and these standards that FDA is going to be inspecting against for an outsourcing facility. So during the inspection, anyone wants to prep for the inspection, this is exactly this guidance, and these criteria are what FDA is looking for, and the outsourcing facility should be ready to go on this score. Okay, let's see, do we have any questions before we move to actually during the inspection?
My understanding is that all of these are just guidances, and you discussed that the FDA appears to be inspecting are just that. So how or why is the FDA inspecting them?
Well, that is a great question, Vivian. And I just wanted to add to that, the guidance is also saying this box at the top that this is just guidance. It's not binding on the agency or anyone else. However, what FDA is doing is it does come in, it inspects against the guidance, it will issue a 483 for violations of the guidance. That can turn into a warning letter, et cetera, et cetera. Mm-hmm. So yes, this is just guidance. In reality, that's the way it plays out. Is that proper under the law, under the Administrative Procedure Act? Well, that's an entirely different discussion, and one, that has been ongoing in the industry, very frustrating for industry members. Some people like guidance because it gives them a window into FDA's thinking. FDA does allow these guidances to go through a comment period, which could be akin to a kind of, or maybe could be argued to be some kind of process. But at the end of the day, they still have that box at the top. And when we've seen litigation, people going into court to try and sue on these guidances, right? The agency will take the position that they're not final. So it's very frustrating as attorneys in this space to be in this space. And it's frustrating for the regulated entities because it feels as if the agency is having it both ways. Now, practically, because that's what we're talking about in this presentation, the guidances are useful because then you have an idea of what FDA is looking for. The problem is they're allowed to legislate via guidance, which they're actually not allowed to do. So Emily, do you have other thoughts on that?
No, I think that's right. And I think it's true that it's frustrating. But unfortunately, all we can do at this stage, given that it's FDA's position that they're going to do this, the goal then is to just give yourself enough kind of foundation to know what FDA is going to be thinking here. And we'll see kind of how it plays out over time in terms of whether or not there's going to be any sort of pushback, industry wise on this score. But for now, it is what it is, unfortunately.
And on the points that are not big industry issues, it's useful because you can see what they're thinking. But what's really frustrating is when they take industry defining issues that sometimes cut off a whole spectrum of medication, right, in a guidance, because it's very difficult for the industry to challenge that. It basically forces some pharmacy to kind of go at it alone to respond to an inspection. So guidance is a double-edged sword.
Yeah. Okay. Great. Thanks very much. That clarified. Well, I guess clarifies it as much as it can be clarified.
So we've given you the foundation. What we'd like to talk about now is what to expect during an inspection. Basically, what do we do on day one? So typically what will happen is FDA will arrive. It'll be one inspector or two, typically one, but it could be a situation where there may be two, depending on the size or nature of the facility that they're looking to inspect. They will show up unannounced in the morning, and they will be looking to inspect the facility starting right now. So what do? You should ask them for their credentials. Typically, they should be able to provide it. I will say you cannot photocopy them, but you absolutely should take their information down so that you have that information available to you. You will also be provided with a notice of inspection, which is called a Form 482, and you should take a look at it. It should actually list the facility that they're inspecting on it. Sometimes we have seen situations where the inspector has shown up at the wrong facility. So it's always good to actually check that form and make sure that it actually is accurate and that they're actually at the place they are supposed to be. That form also actually provides some useful information in terms of the parameters of the inspection. And while we're going to talk about it in this presentation, it does give a little flavor for what the FDA can inspect and what it can't. But typically, when they show up, the first thing they will ask for is to be placed in an area where they can kind of set up for the inspection, and then they will ask for documents. They also may then want to do a walk around at the facility, at which point they may take samples. They are allowed to. They also can take photographs and video. And we'll discuss the parameters of those a little bit more, but just in general, when you're thinking about when FDA is going to be coming in, they're going to be, going all over the facility. They're going to be taking notes. They're going to be taking photographs. They're going to be talking to individuals if they can, taking samples, looking at documents, and they typically ask for a lot of documents. So it can be labor intensive. So it's important to, while you're preparing for FDA inspections, to have some systems in place for when FDA walks through the door and starts asking for things. I believe that's what happens when you first start the inspection.
And now we're going to hit on kind of some ground rules. So Emily has set the stage. And now what we've seen a lot, obviously it's a very high stress situation. People get nervous and they go into some version of, what I call Stockholm syndrome. They just want to do whatever the inspector needs, be as helpful as possible and get them out of there as quickly as possible. And we all understand that response, but it's an emotional response and kind of a counterproductive response. So it's really important, because everyone has these in their facility, and because you want to maintain order in the inspection and over your facility, that the inspector followed the facility's applicable operating procedures. That sounds ridiculous and very obvious, but we have seen inspectors violate procedures, go into the clean room, potentially contaminating the clean room, and then finding evidence of perhaps their own contamination. So the inspector has to follow the facility's processes. Those processes are there for a reason. You have to remember and trust yourself and your own facility's processes, that there is a reason all those things are in place, and they're very good reasons. So the inspector has to do what everyone else does. Otherwise, it can kind of descend into a situation where the inspector is not really observing what's going on, but creating activity, and then the facility is getting judged by the created activity. So that brings me to my third bullet here, is that, again, the inspector is there to observe documents, to take documents that you have, to observe activity that is ongoing, observe the conditions as they are, not to create activity and not to tell you or your staff or the facility to create activity so the inspector can observe it. They are there to observe activity occurring in the regular, ordinary course of business. This is not a play. We don't create activity. So for example, if there is no compounding happening that day, if there is no compounding the inspector wants to see that is happening that day, we do not do that compounding, because then we're going outside of the ordinary course of business and normal processes. And when we go outside of normal processes, mistakes are made, because the processes, of course, are developed for a reason, and we need to keep the routine. So that piece is very important. And this is the piece that I think gets pushed back on the most during an inspection. And this is the hardest one for people to maintain, although it seems obvious, because this, again, we get into the situation where the facility wants this over. They want the inspector in and they want him out or her out. And I understand that, but that's where the mistakes happen, when the operating procedures are not respected and when we are going outside of things that happen in the ordinary course of business, where we're asked to create documents, create activity. That's where things that don't normally happen in the facility happen, and that's where we get into trouble. So we want to talk a little bit about, just to touch on, there are some new COVID protocols due to COVID-19. They have been doing things a little bit differently. Sometimes inspectors are not just showing up, they will call beforehand, ask for documents to be compiled beforehand. We did see lots of inspectors still going into the facilities during COVID-19, but there were pieces of it that started to happen remote, and there were more remote type of inspections. So we did see that, which were mostly document inspections. Emily?
So what can FDA review during an inspection? So, almost anything essentially in the facility is fair game. So we're talking records, files, papers, processes, controls. They can look at materials, API, containers. They'll inspect equipment, facility design, the compounding areas. They're going to look at the labeling. They're going to look at the packaging. They're going to look at essentially anything bearing on whether a drug can be deemed adulterated or misbranded. So it's important to know when FDA comes in that, for the most part, when they ask for something, you have an obligation to provide it. Rachel's going to talk a little more in a second about there are limits. So it's important to know those limits, but they're few and far between. I also want to stress that when FDA comes in, there is a prohibition to always think about against delaying, denying, refusing, or limiting an inspection. I think it's important to refute any sort of idea up front that you can simply just deny FDA from inspecting the facility, or, for example, closing the facility for the day and hopefully that will just avoid an inspection. You can't do that. There are criminal penalties associated with prohibiting an FDA inspection. And so it's important to know that this is a serious matter. Now, some inspectors you will find will float this idea of, oh, hey, you're prohibiting an inspection. They can't simply do that and then deem all the drug products in the facility adulterated or misbranded. That requires a legal determination. So if the inspector feels that he or she is being denied or limited in his inspection, they have to go up the chain of command, and that has to be a legal determination made as to whether or not you are actually prohibiting an inspection. And at that point, Rachel or I become involved. It becomes more of an attorney issue, and there's a discussion, and usually there's a way to de-escalate it. But to be clear, it's a serious matter. They can't simply just throw it out there and say that there is a prohibition, but it has happened, and it's just something to keep in the back of your mind.
Mm-hmm. So as Emily alluded to, there are some things they cannot inspect. And these are few and far between, but it's important to know these because it changes the type of inspection. So when we started, we talked about that Form 482. That's a notice of an inspection. It could be routine, it could be MedWatch, but if they want the information on this slide, they have to go and get a warrant. Civil warrant, criminal warrant, it's going to be some kind of warrant because their authority under that Form 482 is limited to what we have on this screen and what Emily talked about a little bit before. So one, they do have to conduct inspections at reasonable times within reasonable limits and a reasonable manner. So that's the flip side, that the facility is not allowed to delay, deny, refuse, or engage in kind of shenanigans, some of which Emily outlined. Obviously, you just can't close up and give everybody vacation for a week. Someone tried that. That's a true story we're telling. Cannot do that. But also the agency has to inspect reasonable time, reasonable limits, and a reasonable manner. So those are kind of the two sides of the coin, right? Our obligations, their obligations. And that's codified, that's in the statute. We just have the citation there. And also in the statute is what they may not inspect. And we have had inspectors ask for this. They don't get financial data, no sales data other than shipment data, no pricing data, personnel data, other than the data as to the qualification of the technical and professional personnel, and they don't get any research data. So those are the things they do not get. And those things are printed on the Form 482 that they present to as things they cannot have. And yet still, we see inspectors ask for this. So it's very important that everyone understand what they can and cannot do. Now I want to talk about the records exemption.
Can I just interrupt with a question?
Sure.
So how do they justify asking for that data? You said that it happens quite often. Like the personnel data and the pricing data and all of that's in the financial data. Like, what is the justification, or what is it that they're saying that why they would be looking to examine that?
Well, generally in an inspection, Vivian, what happens is the inspector starts running down a certain line of questioning. Mm-hmm. And it's not like they start out deciding they're going to violate their own statute. That's not what happens. It's just they start running down a certain line of questioning. And for them, the next natural question will be X, right? And then we just have to remind them, no, you're not entitled to this. And usually just by pointing it out on the form. Once it was pointed out on the form, the inspector said, yes, I'm aware of that, but you can always ask. That was burned into my brain, right? And that's true, because anyone can waive their rights at any time. Now, do we think that's a good idea? No, because the inspection, of course, and this is what I tell all my clients, you don't know what the inspection is the beginning of. It could be the beginning of a criminal prosecution, okay? Mm-hmm. The beginning of a civil enforcement action, and it could be a big fat nothing. But all of those things are a possibility. Mm-hmm. So, people have different ideas and different stories. And that inspector, if this goes to criminal prosecution, is going to be nowhere around, right? To be able to say, oh yeah, I knew I shouldn't ask for it. So you just got to think. And this is why it's really, these presentations are really important. And thank you for asking us to do this. But it's also really important that you engage counsel you trust to come up with a strategy of where you land on all of these different risk factors that we're putting out and what you want to do, and have a very good SOP for that inspection, have a game plan before the inspection. I'm jumping ahead because we'll say this at the end, so that you have what you can sort it out and can make rational business decisions about what you want to do about these things before they're there. And, it gets emotional. It just does, right? So that's why it's really important to have a plan and have these things kind of sorted out beforehand.
Okay.
That's a good question. Thank you. So I want to talk for a second about this records exception. Oh, sorry, I'm going to talk about the records.
Yeah, I was going to say.
So really quick about this records exception. So this is just for traditional pharmacies. So section 503A compounding pharmacies, and it is in the statute. It was something that was pretty heavily negotiated and fought for when the DQSA was coming into existence. that, of course, enacted Section 503B and left Section 503A pretty much alone, except taking out that offending advertising piece. People fought to make sure that this remained for traditional pharmacies, but was not there for outsourcing facilities. But the records exception is an exception for FDA to not look at or be entitled to records from a traditional pharmacy. How FDA has interpreted this is that it doesn't apply to compounding pharmacies, but it applies to retail pharmacies only. By the way, that language is nowhere in the statute, okay? But okay, that's the way they're interpreting it. So most traditional pharmacies want to selectively waive this protection because they want to demonstrate to the agency that they are in fact patient-specific, and a very good way, arguably one of the only ways, to demonstrate that is to go ahead and produce the prescriptions, the prescription logs and the prescriptions to show that that is the case. So I just want to say this records exemption is there. It can be selectively waived, but it's essentially not doing very much because of the position that the agency has taken and because of the information they would like to see to police that first piece, which is who are you, right? In this, are you a traditional pharmacy outsourcing facility? And one of the criteria they look at to determine who you are, right, is whether or not you're dispensing pursuant to a patient-specific prescription. So, okay.
So I think it's also important to know, as Rachel mentioned, inspections are stressful, and these inspections can last several weeks. So it's long, it can be frustrating, it's tough on the staff. So again, all of this is to say that it's important just to prepare yourself as much as possible for what could be a very lengthy inspection process. Often we've seen inspectors come for a couple days and then they'll leave and then they'll come back a couple days later. And so it may not necessarily be consistently day after day. It could be a prolonged process over several weeks. So it's important just to know, generally speaking, that this is not going to be typically a fast process. At the conclusion of each inspection day, typically what we do see, though, is that the inspector is going to review the observations to date with facility representatives. We always stress it's important to take notes during these meetings. It gives you a flavor for what the FDA is looking at and what likely will be their line of thinking for the next day and in the days thereafter. It's important just to take notes because you'll want to. It's a lengthy process and you're going to forget things. At the conclusion of the FDA inspection, the inspector will conduct a post-inspection review meeting. That will be a very kind of more formal meeting where the inspector will review all of the observations to date, all of the things that are concerning FDA. They're going to ask questions of the facility representatives, and they're going to read essentially what will be in the Form 483 that the facility will get. It is important in this meeting as well for facility representatives to take notes during this meeting, because not every observation that FDA makes will make its way into the Form 483. But it's important to know what FDA is concerned about, even if it doesn't rise to the level of a Form 483 observation, because it could come up later as you're dealing in the post-inspection world of FDA. Because even if it doesn't make it into the Form 483 now, it could become an issue in a warning letter down the road. So it is always important to have your ducks in a row about everything FDA was looking at and concerned about during the inspection. And then what will happen is you will get the actual Form 483. What we always say is that while FDA is going to try to get you to commit to things and answer things and want resolution during this meeting, what we strongly encourage is taking in the information that the FDA is providing you, taking those notes, making sure you have track of everything that FDA has been saying, and then you will use the Form 483 response as your opportunity to push back or say what you need to say to the inspector. But they will encourage you to do the former, which it can be difficult. We understand that, but that's how we would encourage you handling that end of the wrap-up inspection.
And then, of course, I just want to say a couple things on that, Emily. Of course, that's very contextual. I mean, which is why you have to have a game plan and you should engage an advisor, counsel that you trust, because there are situations where something absurd went onto the Form 483, and we are going to say, oh, no, this one, I'm going to have to get on the phone. Emily's going to have to get on. It's just going to depend on the situation. And I want to say something about the observations. that they may make that don't make it into the Form 483, I mean, those are fair game, but they will expect those to be addressed one way or the other when they come in for subsequent inspection. So even if they don't end up in a warning letter, like Emily said, which they very well may, but let's say they don't, like that's not a free pass either. So those are the things where you have to say, okay, are we going to make this corrective action? Or are we going to go to the mat? What's our plan? So, because that's kind of a free pass in my view, because they've just said it to you. It's not ending up on the Form 483, but it is communication from the agency. And so that just can't be swept under the carpet.
That's a good point.
Yeah. Okay. So effective approach, we always like to end here. You need an SOP and you need to conduct employee training. Again, these are stressful and there has to be a certain amount of autopilot that people are on when it comes to the inspection, because you want to put an accurate picture of the facility forward. And the accurate picture of the facility is not a facility where, again, you're creating activity, this isn't how you operate day to day. So you want to make sure that you have an SOP and training so that everyone is able to show FDA what it's really like, right, at that facility during the inspection. You want to designate someone to interface with FDA. Again, that makes the inspection smoother. It doesn't create chaos and it keeps it organized. You should not let FDA rummage through records. You don't give them full control over your computer system. Again, you want to make sure that you are very carefully, deliberately, and honestly answering all of their questions. And if things descend into chaos, which is basically what these bullets tell you not to do, then you're unable to do that. Take detailed notes. I'm going to make sure that you want a record of the inspection, what happened. Again, with the photo, the same thing. If the inspector takes a photo, you want to take a photo. You want to have a record. Also, don't sign any affidavits or similar statements. No one is under any obligation to sign a sworn statement. A sworn statement requires review by legal counsel. FDA will not allow counsel to review the statement. They say, no, we're not permitting that. Arguably denying assistance of counsel, not sure that's constitutional, but the bottom line is you can say no, and you should, because you should never sign an affidavit or a statement or anything that can and are used in either an enforcement action, a criminal action, whatever, when you're sitting there with the inspector without appropriate assistance of counsel. And you should have daily internal wrap-up meetings so that you can keep track of what was said by the agency, what the interactions were. So again, that you can go in and correct the issues that the agency has found or address them if there's some kind of disagreement that you're going to have with the agency.
And just a few minor points before we end. One additional thing to note, and I'm actually going to steal Rachel's line here, which is that I think it's important to know that FDA is not in the business of giving gold stars. So they are there to find things that are wrong. It's a critical, official, candid examination for them. And so, as much as you hope that you're going to get out of there without getting a Form 483, the odds are likely against you, and that's not why FDA is there. So it's just important to know that you're going to do your best, but FDA is not there to give you a gold star and leave. And just to give you a flavor for what's coming, I wanted to note that FDA's recent 2022 budget request mentioned the word compounding over 50 times. So it is clearly top of mind for FDA in the next year. And also they are anticipating on-site inspections going from 54 in 2020 to at least 127 in 2022. So it's not, we're going to see a lot more movement here in this space. So again, it's a perfect time to get your bearings on what's going to happen during an inspection. Do your due diligence, review the guidance documents, take consideration into what the best approach is for your facility. All of these things will help you because FDA is coming. It's not a question of if, it's a question of when.
Thank you, Emily. Those are really good points. And what we've been saying all along, to piggyback on that, is when they walk in the door, you're going to need a plan. That's what this slide is. you're going to need a plan, you're going to need to be organized, and you're going to need to have advisors that you trust. So if you do all that, you've controlled everything you can control, and the rest, it will give an accurate portrait of your facility, and you'll be able to manage how to interface with FDA, what corrective actions to make. The path then will become clear. So thank you, everyone. There's me. There's Emily. We are at Reed Smith, and there is our contact information. Thank you very much for this opportunity, and thank you, Vivian. And we look forward to doing further presentations and answering any questions anyone may have.
Great. Thank you, everyone.
Thank you for watching. Remember, if you would like ACPE credit for this lecture, click on the link below and register for the class. You won't have to watch the video again, just answer the quiz questions. And don't forget to like this video and subscribe to our channel so you can be updated on all our latest content.